I got some questions about discriminatory lending, and I want to go through just ridiculous hypotheticals to start, but so bear with me, but I want to leave enough time for the substance on the back end. As you know, the Equal Credit Opportunity Act of 1974 prohibits lending institutions from discriminating on the basis of all the usual protected classes, race, religion, national origin, what have you. So I want to just start with just a completely softball hypothetical. If a lending institution was to intentionally or unintentionally, but effectively market their products to groups of people that had the practical effect of reducing minorities, certain religious groups, access to loans, would that constitute a violation of the ECOA?
As I'm sure you know, all of us in the banking regulatory area like to avoid these type of hypotheticals, but I'll try my best to answer. The Equal Credit Opportunity Act implicates not just underwriting decisions, but in across the entire credit transaction. So it can affect collections, it can affect marketing and advertising. You may be aware, Secretary Carson issued a complaint against Facebook for violations of the Fair Housing Act that related to some of these issues about advertising. There is some corollary between the Fair Housing Act and the Equal Credit Opportunity Act, and we're happy to follow up with some of the specific regulations.
Well, I appreciate the nuance. I appreciate the nuance, and that's the challenge of these 5-minute hearings. Is sometimes there's not enough time for nuance, but stipulate that there are some things that within that nuance are indeed problematic. Does the CFPB under your leadership have the authority and or the obligation to investigate and prosecute crimes under the ECOA of the type we just talked about?
Yes.
Okay. And if a company was violating those, is knowledge that their marketing techniques were discriminatory a prerequisite for prosecution, or if their lending practices are discriminatory but were not intentional, does that absolve them of liability?
Yeah, so the Supreme Court, there's jurisprudence on this. It's also in the regulation. There's disparate treatment and disparate impact. And so in the disparate impact context, you need not necessarily prove intentionality to get to liability.
Okay, well, that's consistent with my understanding. So here's now the substantive reason for the question. It has been brought to my attention that a number of folks in the lending industry, when they make a decision whether or not to advertise on Facebook, Facebook cannot share and has refused to share any information about whether the algorithms they use to boost their ad tracking are in fact intentionally targeting certain racial groups, certain classes of people, and could have the practical effect, especially in light of all this news over the last weeks, that Facebook's algorithms have a habit of targeting and amplifying and boosting signals from white supremacist groups like the Proud Boys. Given your prior answers, is a lender that is advertising on a platform that uses algorithms that may prove to be discriminatory or maybe have already been proven to be discriminatory, is that lender potentially guilty of an ECOA violation?
It really depends on the facts and circumstances, but in fact, Facebook in your hypothetical may be liable for that.
And would you have liability or the jurisdiction to pursue a claim against the platform as opposed to the lender, or both?
It depends on the exact activities, but just in like Secretary Carson's complaint where Facebook was making those decisions, in your hypothetical, when a tech company like that is making the decision, they may in fact be liable.
Okay, so last just a question for you as we sit here. If the platform cannot guarantee that their marketing channels are not in some fashion discriminatory in a way that would violate the ECOA, would you advise a lender to continue advertising on that platform?
Well, I'm happy to take, I'd rather take this question for the record because it's a complex one to answer in 9 seconds. But I am very worried about black box algorithms that we have no accountability as to how decisions are made. This is the opposite of relationship banking, and we need to make sure that that firms cannot dodge fair lending laws and anti-discrimination laws under the guise of their secret algorithm.
Thank you very much. I'm out of time. Look forward to following up with your staff afterwards.
Gentlemen,